Hello and welcome to today's webinar on an introduction to directors' disqualification. My name is Eleanor Stevens. I'm an insolvency solicitor of over 25 years experience, working today as a consultant in private practice for Harper James solicitors, among others. I'm frequently called upon to advise our company director clients, either on what not to do in order to avoid a disqualification order on a liquidation or administration, or unfortunately, and somewhat more frequently, to advise on how to react to a claim by the Insolvency Service for a disqualification order against a director or directors. For several years, I was a partner in a firm that was instructed to act on behalf of the government in taking proceedings against directors for misconduct under the Company Directors Disqualification Act. So now you could say that I have turned from gamekeeper to poacher, because I regularly advise directors who find themselves on the receiving end of a disqualification investigation by the Insolvency Service. So in today's webinar, I'm hopefully going to cover a lot of the essentials around this subject, including how can a director be disqualified, who's considered a director for these purposes, what's the potential period of disqualification for directors, what's actually prohibited if you are disqualified, what are the penalties for breaching a disqualification order, what constitutes unfitness to allow for a finding of misconduct, what's the court process for these types of proceedings, including how a cost's dealt with. I'm also going to cover undertakings and the old-style carecraft orders, and then we're going to look at how it might be possible to obtain permission to act as a director despite being disqualified. So, how can a company director be disqualified? There are many provisions in legislation for disqualifying a company director, and far too many for me to do them justice in a 1-hour webinar. So for the purposes of this webinar, I'm going to concentrate on the most common provisions that face company directors of a business that's gone into insolvent liquidation or administration, which is the provision that's contained under Section 6 of the Company Directors Disqualification Act 1986. So when I refer to Section 6 from now on, this is Section 6 of the Company Directors Disqualification Act 1986, which I might also refer to as the CDDA. These proceedings are civil proceedings, but they are sometimes referred to as quasi-criminal for two reasons. Firstly, because sometimes they involve criminal offences, but also because in certain circumstances criminal sanctions might apply if the director breaches a disqualification order.